Today's topic is inheriting debt. Grandma goes on a spending spree before she passes, racks up a whole bunch of credit card bills. Those creditors start calling you. What is your obligation? There's a lot of misconceptions around this. We've done a couple of shorts on it in the past. Today, we're going to take a deeper dive. A quick introductory note. I know we have some new subscribers around here thanks to the recent Sovereign Citizen video. I'm glad y'all enjoyed that. We are going to be doing more of that content in the future, so stay tuned, but that's not today's topic. This is something that's very common for people to run into, and it's something that could save you some money in the future. So I hope you'll stick around. And if not, and you just want to watch sovereign citizens getting pulled out of car windows and getting owned in court, there will be more of that, I promise, just not today. So number one, we're going to talk about general principles with regards to what happens when someone dies with debt. Number two, we're going to talk about the ratification myth and where this comes from. This is a very common source of misinformation. Number three, we're going to talk about some of the shady tactics that these debt collectors often use when they're trying to get money out of an estate. Fourth, we're going to talk about secured debt. What is it, and under what circumstances can you just walk away? Fifth, we're going to talk about defeating claims via state law. This varies in different jurisdictions, but we'll give a general overview. Last but not least, we're going to talk about the difference between moral obligations and legal obligations. First of all, this is state law, so take what I'm saying with a grain of salt because things are going to be a little bit different from one state to the other. However, in nearly all jurisdictions, the estate is responsible for the debt and not the heirs. Now, you can inherit, if you want to, an asset that is subject to a debt. We'll talk a little bit more about that when we get to secured debts and secured creditors. But the general rule in every jurisdiction that I've ever seen, and I think somebody departing from this rule would have serious due process problems, the debt attaches to the estate, not to the heirs. That means that if grandma dies, has a huge debt, and you say, oh my God, there's no way that the estate has enough assets to pay all of this, the answer is really easy. You just walk away. Don't have to pay it. You let the creditors figure it out. You just walk away. Now, that means that you don't get grandma's house, you don't get grandma's car, you don't get grandma's fancy new pens, whatever it may be. But it also means that you don't have to pay off the creditors. You get to walk away and live your own life. So now let's talk about ratification. And this is something, like I said, there's a lot of misinformation about. And I saw some comments on a few of the shorts that were wrong. And I'm going to tell you why they're wrong and why I think it's an understandable misconception. So ratification is a principle from bankruptcy law and contract law, and it doesn't really apply in the probate context. There's a debt that is legally questionable or legally suspect for some reason. For example, a debt that you incurred before you were 18, typically those debts are voidable. If you go and make payments on that debt after you turn 18, suddenly that debt is ratified and becomes enforceable against you in full, even though the day before your 18th birthday, you would have been able to cancel it. Similarly, if you incur a debt, don't make payments, and the creditor neglects to sue you, they let the statute of limitations pass, in a lot of cases, 4-ish years, depending on your jurisdiction, they can't sue you over that debt. Now, if you go and make payments on that debt again after the 4 years has passed, you can revive that debt and be on the hook for the whole amount again, because the statute of limitations in a lot of cases runs from the date of the last payment. So that's where this idea of ratification comes from. This is a real thing in the law, and you can ratify a debt by accidentally making a payment. That's absolutely a thing. It's not a thing in probate because the debt is not in your name. Now, obviously, that's different if you signed a guarantee or something of that nature. We've done other videos on that. I'll try to put a link to it. Next topic, we're going to talk about some of these shady tactics that debt collectors use. They'll call you and they'll say something like, we have good news. We're not holding your client responsible for the debt at this time. Yes, you're not holding my client responsible at this time because you can never hold my client responsible. They phrase it as if, well, we're choosing not to hold your client responsible right now, but we might do that in the future. That's nonsense. They can never hold my client responsible. And a lot of times I have some choice words for them. They'll say something like, well, the family really needs to resolve this debt. That sounds like a legal requirement, but it's not. You don't need to resolve the debt. Another tactic that they'll frequently employ is they'll say, oh, can you make a small payment on the account just to keep the account active? Who cares if the account stays active? They're just trying to get you to make a payment so that they have money that they wouldn't have had otherwise. Moral of the story is, if these creditors are calling you about the debt of a loved one, the debt of a family member who passed, number one, you should view them with absolute suspicion. The only thing they're trying to do is get paid. Number two, don't take anything that they say is true. Don't take anything that they imply as true. Number three, they still have to follow the Fair Debt Collections Practices Act, the FDCPA. So if they're doing bad things, calling you at odd hours or harassing you, then you should call a debt collection lawyer, because you might actually be able to get them to write you a check. Now let's talk about secured debt. Secured debt is debt that has collateral. So for example, a mortgage on a house. Mortgage is for $80, the house is worth $100. That means they can sell the house, and as long as they get at least $80, that $80 debt gets paid. Secured debt is something that there are also some misconceptions about. I had some comments on one of the videos saying, oh, secured debt always gets paid. No matter what, it has to be paid. Well, kind of. Secured debt has the first right to that collateral, meaning if there's an $80 mortgage, they can force the sale of the house in order to satisfy that $80 mortgage. However, if the mortgage is for $100 and the house is worth $80, in other words, if the mortgage is underwater, they don't magically get more money for the sale of the house. Whatever the house sells for, whether it be $80, $70, $60, $50, $90, whatever it may be, if it's enough to satisfy the whole thing, great. If it's not, then the remainder is what we call a deficiency, and it becomes an unsecured debt, and then they get in line with everyone else. So when someone says, well, secured debts have to be paid, yes, if the asset is sufficient to pay the debt, because the secured creditor has first dibs on that asset, they can go take it and sell it. If it's not enough to pay the debt, then it's only guaranteed to be paid to the extent of that asset, and the deficiency, they're just going to be out of luck. Now, I would be remiss if I didn't note that generally secured assets don't get underwater. For the most part, houses don't have mortgages worth more than the value of the house. That happened a whole lot in 2008 and 2009, and the housing crisis, a whole bunch of people just walked away and left the houses, caused a big problem, and tank the economy. Be that as it may, generally it's true that the secured asset is sufficient to pay the debt, but sometimes it's not. And if you don't have your eyes open for that scenario, you might miss an opportunity. Now let's talk about defeating these creditors using state law. Again, there are 50 states, and what's true in Texas is not true in Montana, is not true in Vermont, is not true in California, Florida, so forth, right? So consult a local attorney about what is true in your jurisdiction. However, generally, states provide laws that allow a state to defeat creditors under certain circumstances. This generally includes some sort of notice to the creditor. You send them a letter that says, hey, you might have a claim against this estate. Do you want to present it or not? That starts a clock ticking. If they don't present a claim during that time, it's gone. It's out. So if you're the administrator of an estate, it's definitely in your best interest to get familiar with what are the state laws regarding defeating creditors' claims. Also, some states have wonky rules for homesteads and tools of the trade. Talk to your local counsel. All right, last but not least, I've heard many times people come in and they say, look, I realize that I could do these things to defeat the creditors, but I believe that it's my moral obligation to pay the debt. If you're the executor of an estate and you're paying claims that you don't need to pay, you could be putting yourself in breach of fiduciary duty. So if you're one of those people who feels like, maybe I could legally defeat the claim, but morally I have an obligation to pay it, I'm not going to tell you what you do and don't have a moral obligation to do. What I will tell you is that you might have liability to the beneficiaries. That's all for today's video. I hope you guys enjoyed it. Hope you learned something. If there's another topic that you want to see, put it in the comments. As always, take care, and we'll see you next time.